Thank you, Mr. Chairman, and thank you for holding this hearing. Thank you all for coming. I have the good fortune to represent Hollywood, Burbank, and surrounding communities, and a tremendous number of people in the creative industries. And I always tell my colleagues in Congress it's good for us to spend some time with celebrities because we get an understanding of what celebrity is, and it's not us. When people are trampling you to get the autograph of some actor in a B-level movie or a TV commercial, you get a sense of where you are in the pecking order. But one thing we do share in common with artists is none of us want to see our voice, our likeness used in a deceptive way. None of us want to see that being used to say things we never said, take positions we never held. Frankly, it's terrifying because like you in the creative industries, our reputation really matters. And so, Ms. Wilson or Laney, I wanted to ask you, what's it like to hear some purported recording of yourself that you never made? What would it be like for an artist to hear a song they didn't write with a message they don't support, with a quality that is not up to their own standard, after you spent your whole life trying to create your brand?
I mean, it's detrimental. It's really, really difficult. You know, I try to make sure that everything I say on stage, every interview that I have, is thought out. You know, I know that it's going to stay around forever. I know people can pull it back up. And I mean, there's been times where I have heard something and it sounded so much like me, I was like, did I say that? And it's just really, really scary to think that we're in a time that these kind of things can happen. And I just think there needs to be something done about it.
Well, let me ask our other witnesses that exact point. What should be done about it? Mr. Moore, the companies you represent, some of them are the behemoths in the technology industry. They have a role and a responsibility to take down content that is inauthentic, take down deepfakes. What are your companies doing to make sure that artists don't go through what Ms. Wilson earlier described as the gut punch of seeing their likeness, their voice, their image used in deceptive ways? And I'd like to ask Mr. Mason and Ms. Rothman if they could comment also on both what Mr. Moore says they're doing, but also what you think they should be doing that they're not.
So I think certainly with respect to copyright infringement, for example, many of our platform members have robust schemes to take down material that is infringes on those works, and they use technological means, which I'm sure many of my co-panelists are familiar with, to take them down. That's one part. Another thing they do is they have terms of service against particular kinds of content that they do try to enforce, and to get those things down. As you know, and as you've probably seen, the practice of content moderation is a really complicated one and raises a bunch of issues. The Supreme Court is considering those now, and it considered them last year in the application of Section 230 in a bunch of different cases.
Well, Mr. Moore, let me turn to Mr. Mason on that point, the takedown. What is the experience of your members when they see their voice, their likeness being misused? Does the takedown system work? Do they actually take it down? How quickly do they take it down? How many million views, listens do they get before they're taken down? Is the system working? Is it broken?
In certain occasions it does work. It is very difficult. And a lot of people, I've heard it referred to as a game of whack-a-mole. You take something down here, it pops up over there, you try and take that down. It takes too long, it's too difficult. It's cumbersome for independent artists who don't have the support of major labels, and sometimes they don't have the infrastructure or the staffing that it takes to do all those takedowns. And even some of the larger labels are struggling to chase their own copyright protection.
And if I could ask you, Ms. Rothman, if the companies claim, the platforms claim they don't have the technological means to take them down quicker, is that true? or is this sort of a willful design not to develop the technologies that really could address this?
I think one of the problems, and I agree with Mr. Mason, that it is a game of whack-a-mole, and so whatever legislation is passed, we're going to have the same problem, because there already are laws that address this. So one of the problems is the CDA 230, which I think has limited interest in technological innovation. So I don't want to comment what the companies can or cannot do technologically, but they probably could do more than they currently are. And just a firsthand experience, this is not just about celebrities. I've been impersonated online, and when I said I'm being impersonated, take it down, nothing happened. And when I said someone's using my copyrighted image, it came down immediately. So there is a disconnect, and it's, you know, as Mr. Mason said, their artists have more power than the average person. Regular teenagers, grown-ups, everyone are having their images, including in sexual poses, being circulated, and it's very difficult to get them down because the platforms use Section 230 to, and there, as I mentioned in my submission, there's a circuit split on whether state right of publicity claims are exempted from the 230 immunity from liability or included within it, and that has allowed some defenses in otherwise winning cases, and the platforms need to take some responsibility for taking down this material if we're going to have any effort under any laws, whether you pass new ones or just try to enforce the ones on the books.
Thank you, Mr. Chairman.